So what comes to your mind when you read or when you hear intellectual property? When you write a book, for example, that's right. So when you write a book, it's creation. You have created something. That's right. Ideas, someone they can sell for profit. Yes, it also involves ideas. It involves ideas for creations. Could be, yes. Now, I'm having coffee here. Do you know the brand of my coffee? It's not showing to you. It's because of the it's because of the virtual background. Okay, it's not showing here. Let me. Yeah, Starbucks. Okay, you said Starbucks. Why? Why do you think this is Starbucks? What made you tell me? What made you say that it's a Starbucks? The brand? Okay. By brand, you mean the logo? You saw the logo here? That's right. Correctly. So yes, logo or trademark, brand, they are also an example of intellectual property. That's right. So you do have some sense of what intellectual property is. Now, my intention in this lecture is to help you understand the different types of intellectual property. There are different types. When you write a book, it is one type. When you have a logo, is a different type. So my intention is to help you understand the different types of IP, intellectual property, and what subject matters each type of IP protects. Because they protect different things. And now there's a misconception that people in general, people believe that everything can be patented. No, I'll tell you, no. A book is not patented, for example. We don't protect a book by patent, nor do we protect a brand or a logo by patent. Okay? So it's important. We're going to go through trademarks, copyright, patents, industrial design. So the idea here is to understand uh, those different types of intellectual property and what each of them protects. Okay, so that's the main objective of the chapter of the lecture. Now, let's start by understanding in general terms what intellectual property is. So it's this subcategory of personal property. It's called to be an intangible category. Why intangible? Intangible because we cannot touch. When you have a patent, you actually have a right. When you have a copyright, you have a right. So intellectual property is intangible because they grant the owner right. Okay, that's why they are, they are regarded as intangible. And they refer to ideas, as you mentioned, they may refer to information, and they also refer to creative works, eventually to discoveries, to inventions. So that's what intellectual property is. And the purpose of the legislation of the law is to protect the creation, the invention, in other words, the product, the result of mental effort, and also to encourage the free flow of these new ideas. Well, once I have invested money, invested my time, my knowledge, etc., to come up with a book, the law offers me some protection for my creation, and it encourages me to make my book available to the world. So that's the idea. By giving protection or awarding some protection to the holder, to the owner, it's most likely that the holder, the owner, will allow their creation, invention to be available to the public in general. So this may trigger, this may spark new ideas, new creations, etc. In Canada, it's governed by federal legislation. Most countries actually, but in Canada especially, it's important for us to know it's governed by federal legislation because we know that provinces they also have their exclusive rights, as we saw under section 92 in the Constitution. Act of 1867. So if it's federal legislation in Canada, it means that the rules are the same everywhere in all provinces, territories. Now, we're going to look at four main types. There's five here, but we'll be looking at, confidential information too. But in terms of IP, intellectual property types, we'll be looking at copyright into more details, patents, trademarks, industrial design, and then confidential information. And there's a type of confidential information which is known as trade secrets that is very important to us too. Now, remember, by the end of the lecture, I would like you to be able to understand what copyright protects, what patents protect, what trademarks protect, what an industrial design protects. And then the length of protection, whether registration or application or nothing is required. So those are the types of things I would expect you to know by the end of the lecture. Okay. Now let's start with copyright. Well, you mentioned about a book. So what does copyright protect? Copyright protects literary works, books, articles. Your case law report may be protected by copyright. Computer software, code. Okay, so when you write the code, when you develop a software, you're writing the code, that code is protected by copyright. Movies, they are dramatic works, movies, video, television, theater productions, etc. Musical works, artistic works, paintings, drawings, maps, photographs, etc. Performances, so performances by people in general, musical performances, singers, sound recordings, communication signals. So all these are protected by copyright. So if you think about a book, if you come up with a new software, if you just take a picture now this lecture I'm recording, they are all protected by copyright. So this is what copyright protects: literary works, dramatic, musical, artistic works, performances, sound recordings, communication signals. So now you know what copyright protects. Now let me tell you that only the work itself is protected. The expression of the work, the idea is not protected, but the work itself is protected. So the idea of a new book is not protected, not under copyright. It may be confidential information, but it's not protected under copyright. What is protected is the book itself. After you come up with a book, after you come up with a draft, your idea about a picture is not protected, but the picture itself. You don't need to publish, but you need to take the picture. You need to record, you need to perform. So the actual work will be protected by copyright. Now, your textbook may be reading 50 years for protection, but the correct one is 70. It's just changed this year. And I expect you to remember it's 70 if you have a question in the final exam, because it's current legislation. Now, copyright is protected for 70 years after the author's death. So it's the entire life of the author after they create it, plus 70 years. After 70 years, after the author's death, the work goes into public domain. This is the example for most of Shakespeare's plays. It's in public domain already because it's been a long, long time that Shakespeare passed away. So you know what copyright protects. You know that it protects the work itself, not the idea behind it. And you know that it's protected by 70 years after the author's death. Now, do you need to register? No. Do you need to apply for? No. Copyright protection is automatic. Now, if I take a picture now, it's automatically protected. If by the time I finish recording this lecture, it is protected. So there's no registration required, no application, no formal requirements. It's automatic. Now, can you register? Yes, you can. You can register with the Copyright Office in Canada. But if it's not required, why would you register? Well, two main reasons you would want to register. Again, it's optional. First, you would have a public record of your creation. Do you need a public record? Not necessarily. Eventually, you have other evidence if needed so. But if you want a public record of your creation, yes, you may want to register. You pay $60, $90, something like that to register your copyright. Now, a second reason to register your copyright, it's because all types of intellectual property, copyright, patents, trademarks, industrial design, they are only protected in the country they were created, invented, discovered. So if I came up, now this video, this lecture is being recorded here in Canada, so it's protected only here. Now, if it's registered because of international convention, the Berne Convention, countries that are signatories to that Berne Convention, they also afford protection for Canadian copyright. In other words, when you register copyright in Canada, you get some type of international protection. And I say some type because it's only with countries that are signatories to the Berne Convention. So it's not worldwide, but many countries. Now, it's a good advantage because if someone is violating my rights with a picture I made, so I made a picture yesterday from the fireworks, Canada Day fireworks, and then someone in another country is violating my rights. Well, if that country is a signatory of the Berne Convention and I have registered my picture, well, it's I may have remedies in that country. Okay, so two benefits if you register, but there's no requirement to do so. Copyright is protected automatically. Once you came up with your work, it's already protected. Okay. Now, if you work and if you are paid to create copyright, if copyright is created because of your job duties, then copyright belongs to the employer. Unless the employee and the employer, they have agreed otherwise. So as an employee, unless you agree in the employment agreement that any copyright created belongs to you, unless you agree as such, the copyright belongs to the employer because they are paying you to do that, because you're using the employer's resources. So that's why it belongs to the employer. There are two types of rights related to copyright. There's the economic rights and there's the moral rights. The economic rights, you can sell them. You can lease, you can, donate in a will. So they are economic rights. Let's say I came up with a book. I cannot afford to publish it nationwide. So I sell the economic rights to a publisher. But the moral rights, what are the moral rights? Moral rights are the rights related to my name, to the name of the author. My moral rights, I cannot sell. I cannot assign. So when I sell the economic rights to a publisher, I still keep the moral rights. Meaning that the publisher, owner of the economic rights now, they cannot have my name associated with negative aspects or anything that negatively influences my name, my reputation, my credibility. So those are issues that are protected by the moral rights. I cannot sell my moral rights, but I can waive. When I waive my moral rights, I'm telling the owner of the economic rights, the publisher in this case, that they don't need to attach my name to the work. So I'm waiving my rights. When would I waive? Well, I would waive if I'm really concerned that my name may be attached to detrimental things to my reputation, credibility, and I may not be able to enforce my rights. So I'd better sell my economic rights and waive my moral rights. Okay, keep that in mind. You can sell economic rights. So economic rights are negotiable, can be donated, can be given, etc., but not the moral rights. You either keep the moral rights or you waive your moral rights. Now, are you following so far? Any questions? Any comments? Okay, all good. So there has been a recent decision from the Supreme Court of Canada saying that IP address, you know what IP addresses are. They are the internet address that we log on, the connection we are using. So there's a recent decision from the Supreme Court of Canada saying that IP address is private information. I haven't read the decision fully yet. It's recent. It's been 1 or 2 months. But this changes, or this may change, the enforcement of copyright. Because until this decision, or before this decision, internet service providers, TELUS, Shaw, Rogers, all others, they would inform the copyright holders of the identity or the details of whoever infringed their copyrights. So, for example, here in my house, I watched a film illegally, or I shared a file illegally. So if the copy holder learned about that, they would inquire TELUS or Shaw. In my case, I have Shaw. Say they would inquire Shaw, and Shaw would disclose to them my identity. I'm the subscriber to Shaw. Now, why would they be able to do that? Because they would have access to my IP address, and they would know that that IP address was the one logging on or accessing files illegally or sharing files illegally, etc. Now, it's still to be seen how internet service providers will deal with this situation, because the Supreme Court of Canada just decided that IP address is private information, cannot be disclosed to third parties. I'm not saying they will stop. I'm not saying they will continue. I'm just saying that I need to give news to you about this recent decision from the Supreme Court of Canada. And we still have to wait to see how parties will react, how things will develop. But now, before this decision, the idea was to help copyright holders to enforce their rights. I remember there's this company in Montreal. There may be many others, but I know about this company in Montreal. They would be able to know who watched a film illegally or who did something illegally online. I think it was mostly related to a film. So they would issue a notice to that person, and the notice would be able to be issued because they would have contacted the internet service provider, and the internet service provider would have disclosed their clients' contact details. So now I don't know how these things will work in the future. So we're still to see how things will work. Now, what is violation? What is an infringement of copyright? Well, an infringement of copyright will be if the person benefits from the sale, from the distribution, or any other commercial use of the original content, or of a reproduction of that original content. So if you benefit from a picture I have taken, so I took the picture is mine, belongs to me. So if you sell it, if you use in your merchandise, if you use in ad, promotion, etc., it is a violation. It is an infringement. Plagiarism is also infringement of copyright. So this is very serious. By the way, I should tell you that in one of my other courses, I've caught four or five groups having plagiarized their case law report. They just copy. So don't copy. Now, I'm not expecting you to create new knowledge. No, you can get knowledge from the textbook, from internet, from anywhere. But make sure you cite, make sure you have a reference page, make sure you have in-text citation eventually. Because if you don't do that, you are plagiarizing. You are telling the reader that those thoughts, those words, they belong to you, and they do not belong to you. So properly citing is key to avoid plagiarism. And by the way, plagiarism is something that could lead students to get zero. And those students in that other course, they got zero because this is not allowed. This is against, you can read BCAT's policy, academic integrity policy. It's the 5102, if I'm not mistaken, 5102. So plagiarism, cheating, those are all academic integrity violations. And now plagiarism is related to copyright because you are not properly citing. Okay, so that's what copyright infringement violation is. But there are exceptions. So there are times or situations in which we can use copyrighted content even without asking the author's authorization. This is better known as fair dealing. When we deal with copyright in a fair way, we don't need to ask the author's authorization, and we can use the copyright content and it's not a violation. So for education, well, if you use for your own education, if you're reading a book, if you're preparing your case law report, you can do that as long as you properly cite. Then it's not a violation. So as long as you cite, you can use it. You don't need to ask the author, hey, author, can I use part of your book, your explanation? No, you don't need to, but you have to properly cite. You can use it to make a parody or to make a satire. So you want to make fun of part of a film, music, a song, or a wording text, a poem. Yes, you can do that. However, you cannot play the whole movie, 2-hour movie, and then, for example, you're making a review about the movie, but you're playing the whole movie. No, you can't do that. You would be able to play parts of it, very short parts, because you don't want to avoid people or prevent people from watching the movie at the movies or renting or paying. So if you use for research, again, private study, news reporting, criticism, again, you want to make a review, criticize, you can do that, but as long as it is with short parts. The idea is that the question you would make yourself is, what I'm doing, is it what I'm doing preventing others from purchasing, from buying? Is it what I'm doing preventing the holder, the owner of the copy benefit financially from their creation? So if the answer is no, okay, it should be fair dealing. But if the answer is yes, for example, we are starting this course, and in the first week, the textbook is not available, maybe some issues with the publisher. And I have a copy of chapters 2 and 3 that we use in the first week. So I would be able to share those copies with you because you would still need to purchase the textbook because we would still be covering chapters from 2 to 14. So I wouldn't, by doing that, by sharing copies, full copies of chapters 2 and 3, would not be a violation. Now, if I would share the entire book, then it's a violation, or most of the book. If I shared content in a way that you would not purchase the textbook, well, it would most likely be a violation, infringement. So when you work with the copyright content, you would consider the purpose of your use. Is it education, parody, research, private study, criticism, etc.? The nature, the amount, and any alternatives with dealing with the work. Now, can you record something to watch later? Let's say something is being broadcast live now, this morning, but because you prefer to be here in the lecture instead of watching that live broadcast, you decided to have that recorded. Can you record something Yes, you can. As long as if you are recording for your own benefit, you will watch it later. But you cannot share the file of your recording because then would be a violation. You wouldn't be able to make a party, a big party, sell tickets for that party, and then use the recording. No, because you would be benefiting financially from that recording. So whenever you record, it's okay as long as it is for you to watch later, but you can't share with others. Now, other exceptions would be when you copy legislation, when you copy case law. So any types, any information that you copy, if you want to copy exactly what the author wrote, you will have quotations. So just put in quotations. Usually you change the formatting of the text. You have shorter margins eventually. But again, you are telling, you needed to use that content, either from, could be legislation, case law, could be from a book, anywhere. But you are clearly telling the reader that that part does not belong to you, and it's ipsis literis, it's the very content that was written by someone else. And then you add their details. You can have a footnote, you can have an end note, you would add their information in the reference page or bibliography. We have in other ways, or as a summary here, we have to be honest about content. Is this content mine? Was I the one creating this? Okay. Most of content we use in our studies, research, etc., most, they don't belong to us. We use content from others to prove our thesis, to substantiate our point of argument. But that content is not ours. And this is not a shame. This is not bad. No, it shows that you have researched well, you have collected content, opinion, argument from credible people, credible scholars, authors, and you are adding to your research, you're adding to your article. So that's why we have to be honest. Is this mine? By doing this, am I violating the financial benefit of others, financial benefit of whoever created, came up with it? So that's the question we need to have in mind. There are some other exceptions there. And now remedies. Well, if you own copyright and someone violates it, you can get an injunction. What is an injunction? Stop order. So you would get an order from court for that person or company or entity or party to stop violating your rights. That injunction can be interim or interlocutory, meaning before the trial, or could be permanent after the trial. You could also seek damages if you suffer damages. You recorded a new song. People were sharing your song file freely, and you lost money. You lost royalties, fees. So you would seek damages. Could also be punitive damages eventually if there was bad faith. And by the way, punitive damages are highly used in intellectual property cases, mainly copyright. And then what is new for us? And this is new, and you should know there may be a question in the final exam for you related to this. The Anton Pillar order. The Anton Pillar order is a specific order that seizes the material from the violator, from the infringer. So I have files that I downloaded illegally in my laptop. So if the owner of the files, if the owner of the copyright sues me and seeks an Anton Pillar order, they will have my laptop seized. What is the objective of the Anton Pillar order? It is to preserve the offending material. Now, if I know I am being sued for violation of copyright and I have the evidence in my laptop, I could try to destroy my laptop, put fire in my SSD, HDD. So to avoid that the violator, the infringer, they get rid of the evidence, the author, the owner of the copyright, they would seek this Anton pillar order in a way that my laptop or wherever the offending material is, the violation is, that would be seized and would be kept in court so that evidence would be preserved. So that's the Anton pillar order. All right, some other remedies here. Service providers can be sued, but they can be sued as long as they don't do anything. Let's say YouTube. You can sue YouTube, yes, but only after you notify YouTube that someone is violating your copyright and YouTube didn't do anything. In general, all social media, they will do something. They will usually have a legal department for copyright violation. And even nowadays, I would say after I think the last campaign or two last campaigns, presidential campaigns in the US, they may even have a legal department for fake news, all these things. But for copyright, I'm sure most social media companies, most video providers, they would have a specific copyright complaint department or copyright dealing department, because they know if they don't address, if they don't act actively, they may be sued by the copyright holders. Now, if you have ever uploaded a video on YouTube, you would know that if you have a song in the background, most likely your video won't be uploaded, because YouTube has algorithms that in most cases do not allow videos to be uploaded with a song, because they know the song belongs to someone. So they wouldn't allow. I don't know if you have mechanisms. You probably have mechanisms to reach out to YouTube and say, hey, yes, this music or song is copyrighted. However, I'm making a review or criticism or whatever it is. But in principle, from what I've learned before, if you have a song as a background, YouTube, the algorithm wouldn't allow. It would flag a copyright violation in principle there. Okay, and there's also criminal aspects. There's a violation of copyright may also be a criminal offense. So you may remember, or you may have heard from the news in the past, the Napster guy. There's this Napster guy in the US. He was the creator of this file sharing platform. So people would share any types of files, but mostly songs, videos, films, movies, etc. So I remember the Napster guy was arrested and spent some time in jail. I'm not sure if they are out of jail or not, how long they spent in jail, but in Canada too, there may be criminal consequences for copyright violation. All right, so that's what I wanted to share with you about copyright. Again, very summary, because this is what is very important for you. Copyright protect all these types of works, recordings, performances, signals. Copyright protection is automatic. Registration is benefits to register. And copyright is protected for the life of the author plus 70 years. Now, if copyright is generated in the course of employment, it naturally belongs to the employer, unless employee and employer agreed otherwise. Violation is when there's financial benefit without authorization, without paying the proper fees, etc. Plagiarism is also added there. And there are exceptions. The main one is fair dealing. So when we deal with copyrighted content in a fair way, we're not violating, we're not infringing. And also, there are other exceptions here. Remedies are basically the same remedies we've seen throughout the course during torts, contracts, and others. But we have added here, there's a new order here that is called the Anton Pillar Order. This is for the offending material, the violating material, to be seized so that evidence is protected in court. So that's copyright. Any questions? Any comments? For those who are still there? No? All good? Okay, so let's look at patent now. Can you give me an example of a patent? Can anyone give me an example of a patent you know? Something that is patented. New technology. Yes, new technology, that's right. A product specifically, or a specific technology you may remember or you may know. An invention that is specific. Okay, yeah. Can you give me a specific example? I'll try to help you. I have a smartphone here. What am I touching? What am I touching? Yes, touchscreen. Touchscreen is an example. So if it's technology, touchscreen is patented. Touchscreen, the patent belongs to Apple. Apple sued Samsung and they won. They won over $500 million, but then they decided to settle. So yes, that's an example of a patent. Now the camera, if you look behind, the camera mechanism, a camera is also protected by patent. I don't know who owns this patent. If you think about vaccines, if you think about medicine, drugs, pharmaceuticals, if you think about machineries. So all those inventions could be discovery when a new chemical entity is discovered for a drug, for a medicine. So those are subject that may be patented. So you see, I come up with a book. The book is automatically protected by copyright. But if I come up with a specific product that comes from a specific technology, there's a specific processing or manufacturing process, it may be patented. If you think about Lego, you know the Lego, the toy building bricks. So Lego one attaches to the other. Yeah, Lego was patented. And I say was because it's expired now. So those are the types of things that may be patented, okay? So you see that in an iPhone, for example, I have an iPhone. So in an iPhone, we have patent in the touchscreen. There's patent in the camera mechanism. There may be other patents I'm not aware of. Is there any copyright protection here in the iPhone? Can you think about copyright protection? What do you think? Is there any copyright protection in an iPhone? Yes. iOS? Yes, very good. The software. The operating system of Apple, iOS. Yes. Also the user's manual. The user's manual is a book. It's like a book. So the manual is protected by copyright. So you see one product, the iPhone, protected by patent, touchscreen, camera, other things, and also protected by copyright. The operating system, the apps. Is it possible to patent a specific color? Yes, it could be. As long as you are, well, if you come up with a manufacturing process for a color, yes, you could patent that. It's the manufacturing process and it's the end product. There may be an exception there. I need to let me look into more details about patenting colors. But in principle, I believe yes. But during the break, I'll look into this and I'll get back with regards to color. Because one thing is, yes, the process could be possible, but something else that comes to my mind is, well, you have a color. if it's an original color or a specific color. So there may be some exceptions or some restrictions. So let me look into that. Why only you, but only you invent one color? Yes, let me look into this better, because I just don't want to give you information that is not accurate or precise. But now we're talking about inventions, and the invention has to be new. No one can have a patent for that, because if someone already has a patent, you cannot get a patent. It has to be an original work, has to be unique, distinguishable, useful, and it has to be possible to be built on instructions. Now, when you file a patent application, see here, I'm saying file a patent application. In other words, patent is not protected automatically as copyright is. So you have to file an application. When you file an application, you have to detail what the process is, what the product is. Usually there are drawings, there are instructions. So you have to fully disclose what your invention is. Because if you fail to fully disclose, you may have your patent denied, your patent application denied. I'll show you an example in a minute. So that's what patent protects. Again, vaccines, touchscreen, as I said, machinery, inventions in general. Now, you cannot patent scientific principles. Computer programs, yes, you can, but this is something new. This is something more recent. I won't get into details here. Just giving you the news that, yes, in some specific cases, computer programs may be patented. So companies would get copyright protection on the code, and also patent protection on the program itself. But there are specific requirements. So for us, we're not a specialized course in intellectual property. All you need to know is that, yes, they may be patented, but we wouldn't go into details here. When it comes to business methods, so because of the Amazon case, now business methods can be patented in Canada. Well, what is the Amazon case? The Amazon case is based on the one-click purchase. You know, the one-click purchase, Amazon is able to store your personal information on cookies. And when you log on to Amazon, they already know what your full name is, what the shipping address is, and your payment method is. So with one click, you can purchase the product. This is an example of a business method. And Amazon applied for this business method patent in the US. It was granted. Remember that it is only national, it's not international. So Amazon came to Canada and applied here too. But here in Canada, that application was denied, because the law said, the Patent Act said, that business methods cannot be patented. Now, Amazon took the Patent Office of Canada to court, and then they were successful. So now, based on case law, business methods, they are most likely patented or patentable in Canada because of the one-click business method from Amazon. So it became a case law in Canada. Now, as I mentioned to you, you have to apply, you send an application to the patent office. The first to apply may be granted a patent, and then the patent will be reviewed. There will be an examiner reviewing. The examiner usually has expertise, knowledge. If we're applying for something related to engineering, something related to biology or chemistry or IT, whatever the matter is, there's usually a patent examiner that has specific knowledge on that matter. So you apply for a patent, the patent may be granted or denied. So if it's granted, you have a monopoly, you have exclusive rights over your patent for 20 years. Usually it's 20 years after patent application, from the date of application. Sometimes it takes too long for the patent to be granted, then this time may be extended, but the general rule is 20 years after the application date. After 20 years, the patent goes into public domain. So anyone can manufacture that invention, that creation. Why? Because there's no patent protection anymore. Okay, so that's usually the case when you go to a pharmacy. Maybe you've been to a pharmacy before in Canada, and the pharmacist would ask you, would you like the brand name or would you like the generics? When they ask the generics, well, the generics should be the same medicine, the same chemical entity, because the patent expired already. So now all other manufacturers, they have access to how to manufacture that product, etc. And because the patent has expired, they can do so. They cannot use the brand, because we'll see in a minute that brand is related to trademark, but they can manufacture the product. Okay, so there's 20 years protection here for patents. So that's patent. Any questions? Any comments besides the color? I'll check the color during the break. All right, so before we go to trademarks, I'll pause. Recording. Okay, so I made some research here, and what I found out is the color itself cannot be patented. What you can patent is a way of mixing colors. So you develop a new machine, a new process that you will mix, that will allow for colors to be mixed. But that's the process, the machine, not the color itself. We'll see now that a color can be trademarked, but not only the color itself, the color attached to the product. So I'll share this link with you. I was reading this blog from Purdue Law School. If you are more interested in going to details on trademarking colors. So you can trademark color that is attached to a product. So it's the logo itself with that specific color, then yes, it could be trademarked. I have a logo for, okay. I have this logo here from, not me, but Starbucks has this green logo here. So they trademark this logo. If someone tries to come up with something similar with the same green, then it's a violation. But it's not that they are trademarking the color itself. It's the logo that has the color. But in this link, you have more details on that. So now let's talk about trademark. So I've just given you an example. You knew before. It's the logo here. What is a trademark? So it could be a logo, a symbol, a term, design, sound, short sound, the color that identifies a product or a company or a service. And the idea of trademark law is to protect consumers. So if I come with a cup like this to you, you know that in principle, the coffee here should be from Starbucks. Why? Because there's the logo here. Now, that's the idea. When you look at this smartphone from the back, you know that this is an Apple smartphone. Why? Because of the logo. So now, excuse me, you told me that there's iOS here, that are the apps protected by copyright. Touchscreen camera protected by patent. And now the logo protected by trademark. So you see a product like the iPhone may have 3 different IPs in terms of protection. So it's protected by copyright, it's protected by patent, and it's protected by logo. Each type protecting specific subject matter. Okay. Now, trademark law is also used for web domains. So if I try to register appleproducts.ca, if that web domain is available, I would be able to register it. However, when Apple finds it out, and if I'm competing with Apple, then they would use trademark law to prove that they own the trademark for Apple, then they would get the web domain to them, or my web domain would be shut down. So web domain is also protected by or relies on trademark law. Now, the trademark is related to the reputation of the company or the service or the product, relationship with customers, identification of product or services. So that's the idea on trademark protection. Now, protection of trademark. Well, first of all, you have to register. It's not an application. It's not automatic protection, but you register it. You apply for registration. Then, if it's granted, and here it's much simpler than a patent, because here the examiner will only look if there's an existing trademark or logo that is conflicting with yours. If it's not, then you probably get the trademark registered, and protection will be for 10 years. However, you can renew indefinitely. So like Coca-Cola may have registered their trademark in the early 20th century or 19th century eventually. And as long as they renew every 10 years, and also they keep the trademark active in business, then they have the trademark for them only. They have exclusive rights on the trademark. So two requirements. You have to, you can renew every 10 years, but you also have to keep on using the trademark. If you stop using, then you lose protection. And because you have registered trademark, then you have a presumption. You have an ownership that is presumed. Okay, so ownership is presumed. You cannot, so the trademark has to be distinctive, cannot be conflicting with the current one, but cannot be obscene or cannot be confusing with another trademark. And surnames, they don't qualify as trademark registration. What else? So I talked about trademark for web domain. Now, if a trademark is used as the name of a product, the example here, Kleenex, then that trademark loses protection because it became so famous that it became the name of a product. You know what Kleenex is? Why do we what is the product behind Kleenex that we refer to as Kleenex? Does anyone know? When you tell someone, hey, can you buy Kleenex for me? What are you asking them to buy? No, not formulas. It maybe Canadians would know better, or someone who's in Canada for a longer time. So Kleenex would be understood as tissue. I do have one here, I think. Yeah, so this is not Kleenex, but yeah, it's tissue. So tissue here, paper, tissue. So Kleenex is known as tissues. Can you get me some Kleenex? Can you get me some tissues? That's what it means. Now, Google, I read some time ago that Google was worried about their trademark becoming a verb, a noun, an adjective. Did you Google that? Did you have a Google search? So people started using the trademark as a noun, a verb, an adjective. So they were actively trying to make people avoid or stop using this as a trademark. as a verb and noun because they know they could lose protection. Now, remedies here for infringement are similar to copyright. So you have injunction, you have until order, you have damages, you have punitive damages. Passing off. So we did see passing off in chapter 4. So passing off is when the owner of a brand, they don't have that brand as a trademark, because you're not obliged to register as a trademark. But let's say I have a coffee shop. My coffee shop is JM, and I have a logo JM, but I haven't registered this logo. It's just a brand, but it's famous here in the neighborhood. Well, because I don't have a trademark, if someone uses my JM brand, I cannot sue under trademark infringement because I don't have a registered trademark. But I could potentially sue them under tort, the tort of passing off. So passing off is this common law remedy under tort that allows brand owners to go after people who are trying to mislead and benefit from their brand that is not a registered trademark. So that's trademark. We have looked at copyright, patent, trademark, and now let's look at industrial design. So industrial design is when the design, the pattern is unique. So industrial design is protecting how attractive, how distinctive the design is. It's not how effective, it's how unique. Let me try to get an industrial design example here. Industrial design. Let me try to get an image. Can I get an image? Okay. Anything. Okay, maybe this one. Let me bring it here. So think about the design of this motorcycle. So it's the design, it's how attractive it is. It's not how efficient or how, no, it's how unique the pattern, the design is. So you can get protection for this. You can get protection for, let's see if there's another one. So cars again. I don't know what this is. Could be, yeah, specific tennis shoes. This kiddo could be. So it's about the design itself, okay? The distinctiveness, the pattern. It's not how good it is or something like that. Now, you can get protection, you have to register, and you can get protection for up to 10 years. So 10 years from registration or 15 from filing, but 10 years, it is because you have 5 years protection, 5-year protection, plus 5. So you get an initial 5-year protection, and then you renew that protection for more 5 years. So here for industrial design, you can only renew once. Trademarks, you can renew indefinitely. Okay, so that's industrial design. Now, I don't know if Apple has any industrial design on the iPhone, for example, but could be, let's say, I don't know, on the curved edges, could be, I don't know, or anything else related to the product. So now, companies would be smart, would be intelligent, if they would seek protection for their products in as many intellectual property types as possible. As I said, there's copyright protection, there's patent protection, there's trademark protection in an iPhone. Okay. Now, when you think about the medicine, the brand or generics, well, the generics, they may offer a similar drug, a similar medicine, but they cannot use the brand. Like Tylenol. So Tylenol, let's say the back pain, one type of Tylenol, the back pain one. Well, other manufacturers may be able to manufacture that very same product, very same pill, or very similar, but they cannot use the words, the trademark, the symbol, Tylenol, because that is registered and can be renewed indefinitely. Okay, so companies would be smart to seek protection as in as many types of intellectual property as they can. All right, so that's industrial design. Well, integrated circuit topography, just mentioning here, but I won't give any attention to this, more related to microchips. Uh, Intellectual property is still developing in the indigenous perspective. So the government is trying to acknowledge discrepancies in the indigenous teachings and also the legal system, our Canadian legal system, but still developing. Now, let's talk about confidential information. Well, confidential information, how do we know information is confidential? Did I make this question before? How do you know information is confidential? I think I asked you before about this. Anyone? It's clearly stated. Exactly. The discloser, whoever has the information and discloses, they have to inform that that information is confidential. They usually have it stated, written, a watermark, or there could be a non-disclosure agreement, NDA, or CDA, confidentiality agreement. Well, all those types, all those ways. Now, confidential information, if confidential information is disclosed and causes the disclosure damage, they may have grounds to sue the the recipient that disclosed illegally the information. Now, one type of confidential information that is important for us here is trade secret. Does anyone know any trade secret, any famous trade secret? Anything that is kept secret and is used in business? Can you think of any? McDonald's sauce could be. I've heard about KFC sauce too. The one I like better is Coca-Cola, the Coca-Cola syrup. It's protected under under trade secret. Now, imagine if Coca-Cola or McDonald's or KFC, if they had applied for a patent, and if that patent had been granted after 20 years, anyone else could manufacture that. So they decided to keep that information secret. And because they kept it secret and they have business advantage, it is classified as trade secret. Now, it may sound surprising to you, but Coca-Cola does not own their formula to the syrup, their syrup formula. They don't own. McDonald's don't own their sauce recipe. The benefit or the advantage of a trade secret is that it is kept secret. Whoever has a trade secret, they don't own it, but they are having a benefit, they are having a competitive advantage while they keep it as a secret. And Coca-Cola is a very good example. They've been keeping it as a secret for over a century now. Now, if it's disclosed, could be accidentally, not in an illegal way, illegal means, but it could be that another company or anyone else would find out how to make Coca-Cola. They would use reverse engineering, technological means. If they were able to do so, this is not a violation. This is not illegal. But Coca-Cola has been lucky and professional so far because no one has been able to manufacture Coca-Cola as it is, to reproduce their formula. Okay? So keep that in mind. A trade secret is not owned. A trade secret is as such because it's kept as a secret. Now, I read once that the Coca-Cola syrup formula would be kept in a vault in a bank in Georgia. Only two people would know the formula at any given time. And those two people, they would never travel in the same airplane, for example. So those are steps to protect their formula and to keep it as a secret. Okay. Now, if you invent something that others could easily find out, or not in a so difficult way find it out, again by applying technological means, you would be better applying for a patent because you would have to disclose anyways, and you would at least have 20-year protection. If you don't apply for a patent and then someone finds out how to make your product in 1, 2, 5, 10 years, then you have no legal remedies because they used legal methods, technological methods to find out how to make your product. Okay, most companies, they invent things, they start using it as a trade secret, or at least they start developing or researching more as a trade secret. They don't share, and then once their invention is ready to go to the market, they will make a decision. They will either decide to apply for a patent or to keep it as a trade secret. So this is going to be a business decision for companies, whether to keep it as a trade secret and whether they will be able to keep it as secret as much as they want, as long as they want, or if they want to apply for a patent. Now, remember that if you want to apply for a patent, you have to apply in any and all countries you want protection for. You need translation, you need patent agents in all countries, etc. So patent application is quite complex and costly. Trademark application used to be a bit complex but costly worldwide, but now with the Madrid Protocol, that is also Canada is part of the Madrid Protocol, and many other countries are signatory to Madrid Protocol. So registration of trademark is much easier in other countries, and protection too. Now, with regards to intellectual property, if you want to go deeper into intellectual property, if this is relevant to your business, to your professional life, it's important to know a little bit about international treaties or conventions that allow for either an international registration, an easier international registration, or automatic protection internationally because of those international treaties or conventions or protocols. So you would go deeper into these. Now, the remedies for confidential information or trade secrets would be if disclosure of information caused harm, and then again, injunctions would be available, damages, accounting. Could also be breach of contract if you are in a NDA, non-disclosure agreement, and you disclose the information, it means you have breached that agreement. So you could be sued under breach of contract too. Now, one last thing I want to mention to you is about private information. Information is protected. Well, there's been quite some incidents of data breach. The most recent one, well, there are some financial institutions with data breach, London Drugs, Life Labs. Well, unfortunately, even CRA had data breach in the past. So this is very sensitive issue, and many companies now, they have our private information. But first of all, what is private information? How do we define private information? Private information is any information that can identify a person. Well, a name identifies a person, but their SIN number could be address, could be phone number, could be email, could even be religious affiliation, political affiliation, if it does describe someone. For example, if we say, let's say in our class, there's only one person that is affiliated to a religion, is religious. And if we refer to that religious person, because only one person has a religion, then the religion would be private information. So any type of information that can identify a person, could be color of the hair, color of the eyes, etc. Now, private information has to be protected by whoever obtains that information. And companies usually obtain private information, or BCAT institutions. BCAT needed your private information, your full name, your address, your email, for specific purposes, for study purposes. So companies that obtain private information, they need to inform the individual the reason why they are obtaining private information. And once they disclose the reason, then they need to obtain consent. So we give consent to companies to get our private information. Now, our consent is given specifically for that purpose. If BCAT wants to use your private information for a different purpose, they want to sell it, they want to use for marketing, they want to use for different purposes, well, then they need to obtain a new consent for that new purpose. Okay? And also, how do we know? Why do we know there's data breach with London Drugs, Life Lab, all those companies? Well, because under the law, under privacy legislation, companies or parties that obtain private information have to obtain consent, they have to disclose the purpose, but they also need to keep our private information safe. They need to keep a record of any data breach, and they need to inform individuals and governmental authorities about any data breach event situation. So that's why we usually know. Now, in Canada, there's both federal and provincial privacy legislation. The BC Privacy Act is a very good one, and was the act that was used against Facebook. There's class action I mentioned to you before. I think this class action is already was already settled by Facebook, but the BC Privacy Act was used for this one. Let me get the Facebook privacy class action. Yeah, so there was a settlement. So this was settled. Is it Canada? Let's see. No, this is United States. So they were also sued in the United States. There's one in Canada too. Yeah, they settled here May 1st. So there was a settlement, but the lawsuit started because of the BC Privacy Act. Oh, this is, yeah, this the information is here. So if you were a member of Facebook, if you lived in BC, Saskatchewan, Manitoba, etc. I think I had shared this with you before. So this class action was only possible because of the BC Privacy Act. There was a privacy violation here. So that's what I wanted to share with you about privacy. It's a very hot topic. If you, in your business venture, if you are a sole proprietor, even if you are a small business person, if you collect private information from people, you are also under all these obligations I mentioned: disclosing purpose, obtaining consent, keeping data safe, and keeping a record of any data breach, informing not only the users affected, but also governmental authorities if that event happened. All right, so that's what I wanted to share with you on intellectual property. Copyright, patents, trademarks, industrial designs, and confidential information and trade secret. Trade secret is one type of confidential information. Questions? Comments? Did you learn anything new? Or anything that was of interest?